So I guess as a starting point for everybody, because this is a Zoom meeting, you're not automatically muted, and we could probably even see your pictures if you felt like it. So please mute yourself. But if you have questions along the way, Patrick's happy to have questions as he goes through. In fact, I think it's to him a sign of life and interest. It makes life easier for him. So please do, if you want to ask a question, just pop up and say, Patrick, I have a question, and I'll answer it. Anyway, I'm going to step back a bit and start officially. We want to acknowledge that this webinar that I am working and Patrick are working on the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We appreciate their stewardship of the lands in the past and look forward to working together with them in the future. The speaker today on drafting affidavits is Patrick Grayer. He's a family law lawyer and a family mediator who works in my neighborhood on Commercial Drive in Vancouver. He's worked for several years as a lawyer. Before that, he worked with clients with supporting adults with mental and physical disabilities, and has worked in other careers before coming into law. Really, that's all I have to say. I think some of you may have had a workshop with Patrick before on drafting affidavits. We figure there's always opportunity for honing your skills, and that it's good for you to have a chance to ask him some questions and things that may have come up in your practice that you want to get advice on. So we're inviting him back. There's also a bunch of new advocates who we want to provide this training for. So I'll let Patrick start. And as I say, if you have questions, he's happy to just have you pop up and ask them. So unmute yourself and ask them. If you want to do it in chat, you can do that too. I'll watch the chat and let Patrick know if anything comes up. Okay, thank you.
Thanks, Lois. So yeah, welcome everybody. I didn't do this workshop. I did one on Supreme Court forms perhaps last year or the year before. So some of you may have been there. And I really do encourage you. I do this workshop with law students doing clinical semesters a couple times a year. And it's a smaller group, but it really works better if people ask questions. So really interrupt me. I'm happy to have questions. I've kind of put together something basic. Some of you may, I think a lot of you actually do draft affidavits pretty regularly. So some of this may be old news. I put together some of the basics, and at the end, some more interactive stuff around writing materials and rephrasing materials that you might get from your clients. So that's me. That's my name. Let's go to the next slide. So what's the purpose of an affidavit? Like I said, we're going to start with some of the basics. And the purpose of an affidavit is to put sworn written evidence, including documents, before the court without the need for in-person testimony. So it's written evidence, and it's sworn. And the person is called a deponent. And the upside of a affidavit, as opposed to live evidence, is that it allows you to control and frame it in a lot of ways, which is an advantage. I think it's a particular advantage for people who are self-represented, because it gives them a way to present their evidence in a clear, concise form, as opposed to live, not knowing, trying to read from notes, asking a judge asking if you should have notes, etc. They are, however, time-consuming and difficult to prepare. I know as a lawyer, when a client comes to me and they have legal aid hours or they have limited funds, I won't always prepare an affidavit, because I find you'll go to court if you're particularly well in Supreme Court, you'll always use them. But in provincial court, I find you go to the court and a large amount of, many times the judge just says, oh, we're going to send you to hearing and you're going to have to give live evidence anyway. And now you've wasted a bunch of resources putting that into an affidavit. That said, as I already noted, for a self-represented party, it's much more useful in that you already have a framework for your evidence. So as I said here, and They're primarily used when making interim applications in Supreme Court. And there's the rules there, and the rules are dry. But always look at them. And I tell law students this, they think, well, where would I find that? The first place you look is the rules. So in Supreme Court, any application, anything that's interim is done by affidavit, period. Summary trials are the place in Supreme Court where you will use an affidavit for a final order. It doesn't happen all that often, but it does. Desk order, divorce applications have affidavits that have their own forms, and you're probably familiar with those. In provincial court, they are used in hearings, but with permission of the court. And often people don't know that. And different registries are different. For instance, you go to Robson Square, and quite often the practice is a lawyer shows up with an affidavit in their notice of motion. And many who only practice in that registry don't understand that it's actually, you have to seek permission to use it as evidence. And so there's also, I almost never bring an affidavit to a first appearance on anything because I don't know that it's actually going to get used. The exception there is when I'm seeking, and I do a fair few of these, is a protection order. If I'm bringing it ex parte, which I almost always am, because there's safety issues for the person bringing it, almost always a woman. And so brought ex parte, I always use an affidavit, and it's just more concise. And the expectation from a judge is that you are going to bring an affidavit when you do an ex parte application. Ex parte just means without notice. Well, it's a Latin thrown around. The formalities. So affidavits in Supreme Court are generally in Form F30. You can find that form on the Supreme Court website. I find that the ones on the Supreme Court website, the fillable PDFs, are really awkward. So half the time I enter stuff in it and it doesn't end up being there. Could be me. That's entirely possible. But I don't like their forms. I don't know if you have your own templates. If you do, that's great. You can. I find that the templates that are fillable, the Word documents, the Word templates that are fillable that you can get on the Wikibooks, the Click Law, JP Boyd's page, I find are the best forms for people who don't have their own templates. There are specific forms for financial statements that you may be familiar with. These are for affidavit forms, for proof of personal service. I already mentioned the desk order divorce ones. There's a child support affidavit, which I think is F38, and F37 is the standard divorce affidavit. There's also a special form for applications to be a guardian. So Supreme Court Family Rule 10.4 sets out what an affidavit has to look like. And in a couple of slides here, I'll have an example of one. I expect most of you have seen one, but I'll have an example at any rate. It must be in the first person. It's basically a person telling their story. Excuse me. It must show their name, address, and their occupation. I think the occupation is just an archaic thing. But in a city of millions of people, I'm not sure it matters that much, but it is a requirement. And their role. So it'll say, I am, and we'll see in the example, I am the applicant in the file you're in, and I'm the mother of the children, et cetera, et cetera. The deponent must be, the deponent must be identified in the upper right-hand corner of the title page. Sorry, I guess that is correct. It is the affidavit. It should have the deponent, the number of the affidavit. Sometimes that's hard to glean if the person comes to you and they're like, I don't know how many affidavits I've done. Sometimes you won't know unless you get the whole court file, but it should say affidavit number 4. Some people do affidavits sequentially in number and don't include financial statements as an affidavit, even though technically they are. Some do. Just choose one and stick with it. And of course, the date it was made. It's set out in paragraphs, consecutively numbered paragraphs. So don't make paragraphs long. You want kind of a single thought or a single idea to be in each paragraph. And even if that paragraph gets long with that single idea, find a way to break it up. Judges are not going to read a paragraph that's a third of a page, or they will, but the brain naturally skims that and tries to find the important information and finds and reads the beginning of every paragraph more closely. You don't want something important lost because it's in the fourth sentence of your paragraph in your affidavit. So they should be short. The shorter, the better. Err on the side of having them be short, even if they seem a little awkward, than being long. Exhibits. So exhibits are documents that are attached to, it's as if you're giving evidence and your client is on the stand and you say, you know, how much is remaining on the mortgage of the family home? And they say, well, this much is this $348,000 is remaining. And you hand up a document and you say, do you recognize this document? Yes, I do. It's my mortgage statement. That's what you're attaching as exhibits. You're attaching mortgage statements. You're attaching photographs, and we'll get to what you should and shouldn't attach, but those are exhibits and they should be sequentially numbered as well. So let's say the narrative of your actual affidavit is 6 pages long, and then you have 40 pages of affidavits. The affidavit should start at page 7 and end at page 46, and they should be numbered in the top end corner. It is a pain in the ass if you don't. I have done it myself where I have a 50-page affidavit and it has 5 pages of narrative and 45 pages of exhibits, and they don't have numbers on them. And every time I want to have a judge turn to an exhibit as I'm taking that judge through the affidavit, I have to say, oh, we'll go to page 5 and now we're going to count. You lick your thumb and you're turning over 1, 2, 3, 4. Are you with me, Judge? 5, 6. And you're counting over 30 pages to get to the right page. And you're doing it every time you want to refer to something. It's frustrating and it doesn't make the judge your friend. The person who takes the affidavit, so usually a lawyer or a notary, they will, after the deponent swears the affidavit, that the lawyer or the notary will then on each individual, not each individual page, but on each individual exhibit will fill in this information, the name of the person swearing it, the date, and then sign it. So when I do it, I put in that information and I sign it on each exhibit. So the deponent doesn't have to sign it, just the person taking the oath. Did someone say my name? No, I was just hopeful. So yes.
Sorry, there is a question.
Oh, okay.
Hi, just a style question, Patrick.
Yeah.
I'm wondering if it's possible to put I've sort of done this on some of my affidavits, and maybe that'll get me in trouble. I've gotten away with it so far, but I'll often put a blank page in between each exhibit where the tab would be, and mark that in sort of my Adobe PDF reader document as exhibit A, B, C, and so forth. And I place the certificate on that page. And I find that makes it much easier to find a legible place so that I'm not covering up text. I just find documents can be quite messy. Is that maybe a faux pas, something to be avoided, or do you know?
No, that's fine.
That's great.
I think. I mean, if you've been getting away with it till now, it is a problem. I mean, you have a tax document, it fills right to the edges of the document. Where do you put the stamp? You don't want to put your signature on top of something. I generally just find somewhere, at some point, that doesn't matter what the return address on CRA is. But yeah, it does get messy. I have seen people do that, where you put in a separate page. This is exhibit C, and it's a blank page. And I think that works. Yeah. And if you haven't had anyone come back to you and say it hasn't worked, then I think that's a good indication that it's okay.
Okay, well, I'll continue. And if somebody slaps my wrist, I'll let you know.
Yeah, maybe I'll even start doing that. Every now and then I think, this could be one where I do that. And then I think, then I have to do it for every exhibit, and I get lazy and I don't. So the provincial court, they have a form 417. Provincial court actually has handwritten forms that you can use. They also have downloadable, fillable PDFs from their website. Again, I find them awkward. They have very few actual rules about affidavits. So they have a separate affidavit form for financial statements, proof of service, and again, guardianship. But then they just have a general affidavit form. There are very few rules in Provincial Court Family Rule 13. One of them is you have to apply to a judge to use them in a hearing. But as far as the formalities that we just went through with Supreme Court, there really aren't any. So best practice is just to use the rules that exist in the Supreme Court Family Rules, follow those as closely as you can. Sometimes if you're using your own template and you think, oh, can I put this in? Pull up their form and see how they formatted out the Provincial Court. Funnily enough, I find the Provincial Court Registry is a little more rigid about what they will accept. But I'm not sure why, but when they don't have as many rules, I don't know if it's what the story is there, but I do find that. So yeah, use the Supreme Court guidelines when you're drafting Provincial Court affidavits. And as I said, you do need permission. Think about, I mean, it might be different in your context, but as a lawyer, I think about resources when I'm doing that. Here's one, an affidavit. It looks kind of tiny on one screen and big. Can you guys all see it? I guess I can't actually get responses. Hopefully you can see it. This is what the first page of an affidavit looks like. And again, maybe all of you have seen one of these, but you'll see there in the upper right-hand corner, it says, this is the first affidavit of Jane Doe in this case and was made on, and there you'd have the date and there you'd have the court file number and you'll see the registry. This one's supposed to be in New Westminster, or is. So this is a Supreme Court affidavit, and then it has the style of clause, the claimant and the respondent. And then you'll see it says, I, Jane Doe, and then you have address, you have occupation, affirm that. Mine, I think, says swear or affirm that, and I think affirms in brackets, but mostly people affirm, I find. Anyway, the address, there's a note there. I generally just use my address at my office as the address, particularly, I mean, it becomes critical where you're doing an application for a file that involves family violence and the person doesn't want their address included. Then it becomes particularly relevant. But I just, as a rule, use my address. Now, I don't know if you can do that, but you can use a friend's address. You could use I guess if you work in a nonprofit, you could use the nonprofit address. This doesn't necessarily, you can use just the city and the province. I don't know if that was a question.
There is a question, and
excellent.
You love questions. David,
I do.
Someone is just asking if you can use AKA for also known as, or do you have to, I guess, do the whole thing out or not?
In the style of cause, I always write out also known as.
Okay.
So the style of cause is the top there under Supreme Court, claimant, respondent. I always write as also known as. I don't know. I've never tried to write AKA up there. It might be okay. But I've always written that. The line below there, I, Jane Doe, I have in that line put AKA just to make it shorter. But I think when in doubt, use the full phrase just to be careful. I doubt you're going to get, sorry?
No, I just want to remind people they can unmute themselves to ask questions, but
yeah, of course.
Fine. You got that one answered. Thank you.
Yeah. I don't think you're going to get an affidavit bounce for putting I, Jane Doe, AKA Jane Deere. I noticed they haven't even put the AKA in this one, which is interesting, on that line there where they affirm, right? This affidavit, I make this affidavit in support of my notice of application. I don't always put that in, but you can. Usually I would put I am the claimant herein and the applicant in this application. So this looks like it's used for a application for service. I'd usually put in the first, in the line if there's children. If I was Jane Doe, I would put I am the mother of the two children, subject children in this proceeding. They haven't done that here. this is what, so I skipped through this. You can see is page 12, I believe, of the affidavit. I didn't put up all 12 pages. I wanted to show you what the first and last page. So let's go back one here. So again, you can see they're very short paragraphs, right? The respondent, now referred to as John, and I met in Mexico City. Mexico. John lived in, there should be a period there. John lived in Mexico City at the time, and I was there visiting my family. I stayed in New York for approximately 6 weeks. And this isn't particularly coherent. I apologize. When I returned home, we maintained a long distance relationship. John wanted to relocate to British Columbia and started making plans to do so. So you can see that each one of these is a very short and has one idea. When really, if you look at that, the first couple of paragraphs are all kind of about the same thing, but you're breaking them down and each one is only a sentence or two long. These are a little longer, but they have an exhibit, which makes, paragraph 57 has an exhibit, which makes it longer. And this is the last page. So this is where Joan would sign her signature. And again, excuse me, note they don't have the AKA in there next to her name. And this is where the commissioner, which is your lawyer or notary, would sign and put their stamp or write in their name below the commissioner for taking, and the signature goes above. You'll see there's a reference to an exhibit there, and that's what a reference to an exhibit looks like in the actual body of an affidavit, right? Talking about banking online joint account, and then they say, looks like there's an email. So I emailed the respondent on January 12, 2014, asking him about the mistake. And he replied by email on January 14, 2014, advising that he had canceled the regular deposits, would transfer $250 into the account, and then I could, quote unquote, live off that. Attached herein and marked Exhibit S is a copy of that email. And that's the general language that you use for attaching an exhibit. Some people write it all out again. Attached herein and marked as Exhibit S to this, my affidavit, is a true copy of the email from John to me on January 14th, 2014. Some people write it all out. Again, I think this is effective. It's clear what you're referring to. And that would be Exhibit S. So then on that document, somewhere down the line, you'd put that stamp and the lawyer that will sign it saying this is Exhibit S, right? When you refer to Exhibit S further into the body of the affidavit, this is the last page, but if you were to refer to it again, you wouldn't put all of the formalities. You would just say, let's say you referred back, you were talking about how you couldn't live off the money that was offered to you. And then you would, in the email referred to at Exhibit S. That's all you'd say. You don't have to lay it out each time with the formal language. You just do it when you introduce the exhibit. What should be included? I was told I needed to put in some pictures. You can't handle the truth. Jack Nicholson was very good at playing a jerk. I don't know if you know that film. The facts. So what's in an affidavit? You're basically putting in the facts which supports your client's position, right? In a objective, dispassionate nature. And by dispassionate meaning, we'll get to that. You're not putting in a ton of adjectives. You're trying to keep it clear, concise, and seemingly objective. Now, of course, objectivity is everyone has their own objectivity, like they have their own truth, but you're trying to put it in a clear and concise way. At a minimum, an affidavit should set out the facts on which the application is advanced or opposed in a concise, logical, and factually accurate manner. So sometimes you have to remember that too. Clients will be saying to you, well, what about this, this, and this, and this, and this? And you have to come back to what you're actually applying for. Okay, well, it's relevant to the whole proceeding, and it might be relevant to other issues in your proceeding, but right now, this is what we're applying for, and this is what's relevant. They have to be admissible under the Evidence Acts, the Rules of Court, and the common law rules governing evidence. So that becomes difficult. That's difficult for a lot of lawyers. I find it's difficult, in particular, somehow for family lawyers. A lot of family lawyers seem to think there's different rules of evidence for families family law proceedings, and there aren't. So it's good to know those. Are you ever going to know them inside out? No. Most lawyers don't. And like I said, a lot of lawyers either don't know them or like to ignore them, but you should know as much as you can. This is client interviews when you're interviewing a client because you're going to draft an affidavit on a certain subject. This is probably an area where this crowd has a lot more expertise than the law students I get who are coming out of law school and don't always have a ton of life experience or a ton of actual practical experience. And I say to them, look, listen, always listen all the way through. Sometimes no one's ever heard this story before. They also don't know you. People come to my office and they've never met me before, and they're now telling me, some of their most intimate secrets, and they don't know me, and it's difficult. And I actually always predicate my first interview with, just recognizing that. Now, probably this crowd, you have a lot more experience with that kind of thing, and you probably have your own way to interview clients. I always make sure that I remind them that this is a sworn statement of evidence, because, they're not sitting there in front of a judge. It's not the same practically. They're not nervous because they're in a courtroom. But so you have to really hammer that home. Look, you could be cross-examined on this. Something happens in 10 years and some opposing lawyer can pull out your affidavit and ask you why you said this. So you want to make sure that it's accurate. And, try and make your client a little nervous about that. One of the important things I find too is that I think it's our natural inclination, and some people more than others, that clients don't always want to tell you the whole story. They don't want, and it may not be hiding, and maybe I shouldn't use the term hide, but evidence that's harmful to them, they don't necessarily always want to volunteer it, right? But I tell them, look, it's better that I know now for a couple of reasons. A, I won't get surprised by it when you're asked, well, what about X on the stand? And I have no idea. And I never asked you about it, and I don't even know how to redirect you, or we're going to scramble out in the hallway on the break and try and figure, well, when your cross-examination is done, so I'm not allowed to talk to you, and figure out what happened there. So you want to know in advance so you can react to it. You also want to know in advance so you can frame it, right? Evidence that hurts you, it's better you're upfront about it. It doesn't look like you are hiding something. And you can also frame it, because perhaps it's not as it looks when it's framed by the other party. I was using an example where there has been family violence. And let's say there's an incident of family violence where the man is violent with the woman, and he's got her up against the wall and he's strangling her, and there's this long history, and she tells you, oh, he was strangling me, and then I got away from him and I ran out the door. And that's what you put in your affidavit. And then on cross-examination, they pull out a picture, and it's the picture of the man after he fell and hit his head on the coffee table because she pushed him to get away, and he fell and hit his head on the coffee table. He's got a giant gash and blood all over his face. Now you have a situation where the opposing counsel puts this picture and said, well, who got injured here? Really, what happened? Right? What did you do where were your injuries? Because here's the injuries sustained by my client. I put it to you that you were the aggressor, et cetera, right? If you frame that, though, there might be a perfectly reasonable explanation, right? Yeah, he was strangling me. This was the 5th time this had happened. I thought he was going to kill me. I got lucky and I saw a way out. I gave him a push. He fell over and hit his head on the coffee table, and I ran out the door. That's you want to frame that and put it in your affidavit, right? If you're looking for trying to get a protection order, that's much better than having it surprise you. Because no matter what happens when they surprise you with it, it looks like you're hiding it. If you frame it, you say, yeah, that's exactly what happened. It's much better to do it that way. On ex parte, and again, that means without notice applications, where when you're normally doing an affidavit and you're doing it to support whatever application you're bringing, whatever it is you're looking for. and you're putting in all the facts. You aren't obliged to put in the facts that don't help you, and sometimes you won't. And sometimes you will, just like I said, because you want to frame it, but sometimes you won't. In an ex parte application, which the only time I ever really do them is for protection orders, you have a duty to disclose all of the relevant facts, even those that support the other side's position, right? And excuse me, and it can hurt you if you don't. For instance, if you go in without notice and you put in an affidavit and it says X, Y, and Z, and the judge gives you the protection order and says, okay, I'm giving the other party, they can come back, as a protection, wrong, bad word to use, as a fail-safe, the other party can try and set aside this application on 2 days notice. They'll shorten the limitation in order to give, or the notice provision, so that you can come back quickly to have it set aside, because it's highly prejudicial and you've done it without notice. If that person then files an application to set the protection order aside, and there's all sorts of evidence there that you didn't include, they will come back. And if I was doing that, I would come back and say, look, this was all very clearly evidence that the applicant had, and they chose not to put it in when seeking this order, and you will have your order tossed, even where perhaps you had a good application and you had the grounds for the protection order and you had the grounds to maintain that protection order when challenged. You could lose it because you didn't include that information. So that's another reason why in that example that I just gave, where you're applying for a protection order and there was this incident of violence, not only can you frame it, but you need to provide that information, because not only are you now being ambushed with that information and trying to react, but the opposing counsel, if they're good at their job, is going to say, well, they also didn't include this information, or, what else are they hiding? And your client has less credibility and stands to lose the protection order. Okay, so as much as possible, when you're writing an affidavit, use plain language. You don't want to use fancy legal terms. You don't want to, even saw a critique of an affidavit by a judge recently who said, these people are, they run a restaurant, and it was a civil suit, and they were suing somebody. They spoke multiple languages, but English wasn't their first language. And the judge said, why are there affidavits that are supposed to be their language using all these technical business terms and legal terms? And said, look, this affidavit, I can't even be sure this is their evidence. So, you certainly don't want to use slang, and you don't want to use, you want to use proper punctuation and proper grammar, but plain language is better. You definitely want to be concise. Longer is not better. You want to cut it down as much as possible. You can even say, look, where I'm trying to, and I somehow always come back to examples of family violence, because they're the most kind of complex affidavits that I write generally. But let's say someone comes to me and they have a 20-year history of family violence, and there's emotional violence, there's financial violence, there's physical. I am not going to write out an affidavit that's 120 pages long necessarily, explaining every time the other party was verbally abusive. I will have some general comments. Look, the respondent was, he verbally abused me on a regular basis. It probably happened 3 or 4 times a week. These are the things that he would call me, and I'd list a bunch of terms that are specific quotes of what he called. Like if he was insulting my client, I'll put down in quotes what the words that they used. I will then use some actual specific examples of things that happen, particularly where there's physical violence. I will say, almost always where there's lots of physical violence, I'll go through almost all of it. But and then use some of the more egregious examples and actually go through those in detail. But I'm not going to write a 120-page affidavit saying, he called me this, and then he called me this, and then he called me this, and then he called me this. Those people don't remember. And I think that's important to acknowledge too. People will often come to me and say, well, I can't remember when that was, so I can't use it. And it's, yes, you can. Judges understand that your memory is fallible. I mean, most judges are over 50. They know that memory is fallible. And they understand that people can't remember precisely. And sometimes people will remember things. I remember we separated on Canada Day because we were at a barbecue. Sure. But you won't always. So it doesn't mean you can't use it, right? You can say it was summer. We were outside. We were at a barbecue. It must have been July or August 2013, right? And you can say on or about. You can use that language. But people need to know that just because they can't remember exactly, that they can still use evidence. Lots of people think that evidence means documents, or evidence means it has to be corroborated by other people. And it doesn't. Your telling of a story is evidence. It's your evidence. This is what happened to me. That's evidence. It's great if you have other people who were there and saw it and can corroborate it. It's great if you have documents to support your evidence, but you don't always. A lot of stuff happens behind closed doors. They were the only people there. So in those circumstances, when I write an affidavit, again, I'm going to use family violence as an example. If I put in quite a detailed narrative, again, keeping it as concise as I can, contradict myself there. And you have some detail, and this is what happened, and this happened to me, and this happened to the children, and he said this, and then he took away my phone, and then, and then the other party just comes back and says, oh, none of that ever happened. Well, what you have now is you really only have he said, she said evidence. There's no one, generally not going to be anybody there to see it. You're not going to have any documents. Maybe you'll have pictures of some injuries sustained or some things broken in the house, perhaps, and that will help. But really the evidence there is your detail. It's much more believable if you have a narrative that has some detail in it. This happened on, roughly this day. And, usually something really dramatic and people can pick a day because they called somebody and they have a record of it in their phone, or they emailed somebody and they texted somebody and they have a record of it in their phone. And it's gold when someone comes back and just says that never happened. Because who are you going to believe? The person who has this kind of believable, detailed story, or someone who just denies things? So that's useful. They should generally be typewritten. Don't use legal terms. Use headings for new topics. I can't remember if the example, if we did that here. I'm going to try not to make everybody seasick. Yeah, see my financial circumstances, background. Background's always a good thing to put in too. And maybe I have a slide about this, but I'll say it now anyway. Background, if you go into Supreme Court in chambers and you're in front of a judge and they have 40 things on their list that day, you can be hopeful that they've read the materials you've put in front of them. Maybe not. And that's actually one of my first questions. Have you read the materials? So that'll tell me how much I need to go through them. But you can be guaranteed in Supreme Court, they won't have the file in front of them. So they won't have read the pleadings. They won't have any idea what's going on. So you generally put in background that's relevant. We were married on, we have these kids. I live here, we split up and the kids now live with me. Attach your court orders if you have any, attach agreements if you have any. This is the background about our relationship or about whatever it is you're addressing, right? Do that. Your narrative should generally be chronological. You're generally telling a story and it's linear, it's chronological. Opening paragraphs, again, there you go. It's just what I'm talking about. In the provincial court, they will have the file in front of them, but the clerk will just put it in front of them. The chances of, or sometimes they have it, but the chances of them having read previous affidavits and having background is unlikely. So here's, we're talking about exhibits. In general, only those documents will actually serve to improve the likelihood that the client's evidence is true should be attached. So for instance, Lydia is doing well at her new school, report cards from old school, new school, attendance records. I deposited my share of the house sale proceeds into our joint account. You could put vendor statements of adjustments, trust check, bank statements from joint account, deposit slips, right? I have a blue Ford F-150 pickup truck. You put in insurance documents, a vehicle transfer form, a photograph of the truck or a lease, financing agreement. And again, I'm telling you how important it is to punctuate. The punctuation isn't great there. Photographs. People always want to put in photographs. There aren't often that many photographs that are relevant. Sometimes there are. The photographs of the truck, the photographs of the injuries. Do not put in happy parent photographs. They are close to useless. People always want to say, look, I have a great relationship with my children. Here's a picture of us all smiling together. Everyone smiles to the camera. It's not really indicative of your relationship. It just fills up an affidavit and a judge is just going to glaze right over it. And in fact, some judges will just get annoyed. The same with letters. Generally, letters aren't admissible. They are, all they prove is that a letter was written. Nothing in the letter itself is actually evidence, right? Because people can write whatever they want in a letter. Character letters are kind of worse than useless, to use that expression again, because they're biased. And judges know that. So, I mean, there are times when you might use evidence from someone and say your client's ability to parent is being impugned. You might want evidence from other people saying, normally you wouldn't do this, but if they're attacking your client's ability to parent, you might say, well, no, here's some people who saw my client parent who says she does a good job. Now they might be a little biased, but the thing there is, again, a letter is just hearsay, and you would actually want the person who saw that parenting to write their own affidavit so that it's not hearsay, and then they can be cross-examined on it. Now, the type of things that you can use are business records. So mostly evidence has to come from the person who created it, right? And we'll get into what hearsay is. Hearsay is when you're using evidence that someone else has told you, right? And how I said those letters, how letters don't, the contents of the letter is not evidence, right? It's only evidence that someone put that on paper. Doesn't actually mean it's true. And people get confused by that. Well, it says in the letter, well, you can say anything you want. Business records are something different. Business records are records that are created in the course of that person's normal duties, right? So there's a list of them here. Personal income tax returns. So someone created those at CRA and that's their job. They have no vested interest in your family law proceeding. They're not biased necessarily. They shouldn't be. They've just created this personal income tax return each year because that's what they do and it's their job. You can use those. You can attach those with your affidavit without having to call the person from CRA who works in the Surrey office who created that document to verify that it's true, right? The same with corporate income tax records, bank statements. You'll often see these attached to all kinds of financial statements that are created by the institution. I guess it is possible someone could forge them, but highly unlikely. I haven't seen it yet, or if it has been done, it got by me. School report cards and educational assessments, medical, dental, and psychiatric reports, estimates, and quotes. That one's a little iffy at times, though. You're not allowed to have medical records that say, for instance, give an opinion, right? So, for instance, the medical record could say X had surgery. This was their injury. This is what we went in and we did surgery. But if it says, well, and it's going to take them 9 months to recover and they're not going to be able to work, Now it's not admissible because there's opinion in there from the doctor, and the opposing party has should have the opportunity to ask that doctor, why do you think they can't work for 9 months? If the document just says they had surgery, they were in the hospital for 5 days, we sent them home with this medication, you can use that part. Now, you can often just put the document in and then say, I'm not relying on the part that's opinion. But you have to be a little bit careful with medical records. Receipts, invoices, bills, and account statements. Generally speaking, unless they're some kind of handwritten thing, if it's a receipt from wherever, from, some business, it's a receipt from the brick because you bought a new fridge for the family home before you separated. You can attach that. And documents from ICBC are also generally admissible. This is interesting in that children's evidence has a special place, and we'll get into what hearsay is. And like I said, hearsay is evidence that someone else has told you, right? That you didn't witness yourself. They recognize, and the law has changed a lot in the last 20 or 30 years, that really, unless you allow children's hearsay evidence, you're almost never going to hear from a child. Because you don't put children on the stand very often. You might get a Section 211 report, a special report that tells you the views of the child, but you're not always going to do that. And so you're going to want to be able to have your clients, when they're telling their story, to be able to say, my child told me this, or when this happened, my child was crying. Now, you want to be careful, and again, we'll get into this a little bit. You want to be careful not to read into it. You can't have your client say, my child was upset, because now you're saying what's in their mind, right? What you can say is, my child was crying. My child told me he wanted to go to soccer practice, and that's why, he was crying. You can give all of the visible cues to why that child might have been upset. All the observations you've made, you can give all the things that the child said that were relevant to why they might be upset. But it's going to be that's argument 2, right? That's when the lawyer will then take that evidence and go, look, the child was upset when this happened, because you're allowed to do that in argument, but that's not evidence. So the Family Law Act chapter, this section 202 allows you to give hearsay evidence where children are concerned. It also allows us judges to interview children if they want to. It rarely happens, but they can. Now, as we saw before, you can use hearsay evidence, or maybe we're going to see that next. You can use hearsay evidence in interim applications and not in final ones. This allows you to use children's hearsay evidence anytime you like, as long as it's reliable. Okay, keep that in mind. So basically, after reading an affidavit, this is what a judge should understand: who's making the affidavit, what their role in the court proceeding is, the history of the parties' relationship. And again, I'm focusing on family law, and my guess is that's what most of you do. The history of the court proceeding so far, the nature of the order the client seeks or opposes, and why they're seeking it, right? What not to include. This is kind of the fun part. Hearsay. So hearsay, and it's a difficult concept. And I've tried to put it in layperson's terms as much as possible. Hearsay is repeating what someone else has said as proof of a fact. For example, saying, Yoko told me that she saw Ted at the park with a Frisbee and a squirrel, to prove that Ted was in the park with a Frisbee and a squirrel, right? So you can use that if you're seeking an interim order, a temporary order, right? It's still better to have, especially if it's really important, it's still better to have Yoko swear her own affidavit to that effect, but you don't have to. But where a final order is concerned, you can't use that at all. The only hearsay evidence you can use in a final order is, as just discussed, children's evidence, right? So even the place where you wouldn't be able to use hearsay in an affidavit, because affidavits are almost always for interim applications is at a summary trial. And a summary trial is for a final order by affidavit. And I guess in desk order divorce applications, but in desk order divorce applications, the forms are so straightforward and conscribed that I don't know where the opportunity to put hearsay in there would be anyway. So yeah, the phrase you hear around hearsay is truth of contents. Is that statement being used for the truth of its contents? And I go back to a letter, right? A letter, the evidence of a letter is that a letter was written. So it can be used for that. What you're not using it for is the truth of its contents. You're not saying what's in that letter is true. You can't, right? Double hearsay. So double hearsay is repeating as a fact what someone else said to someone else. So using the Yoko example, Yoko told me that Ted said he was at the park with a Frisbee and a squirrel. You can never use double hearsay. If you want to get that in, you got to go to Ted, right? Because she didn't actually see Ted. Ted just told her. So you either need someone who saw Ted, or you need Ted to say, I was in the park with the Frisbee and a squirrel as evidence that he was in the park with a Frisbee and a squirrel. Using hearsay without naming the source is never permitted. You can't say somebody told me, right? And this comes into, I'm dealing with this in a file right now. It's not really hearsay, but people often don't want to get involved. And so, people will say, well, my friend told me this, but they don't want me to name them because they don't want to get involved, which is understandable. People rarely want to get in the middle of a court process, let alone get in the middle of a breakdown of a relationship. People are more willing to do that. And they say, look, I just don't want to get involved. You can't use my name. Well, either your client has to decide to use their name without their permission or not use it. Where it becomes more difficult is if you want to go back and get Ted to swear his own affidavit saying he was in the park with a Frisbee and a squirrel, because somehow that's critical to your case. You can't do that.
A question.
Yeah.
Okay, so say you are going to be using hearsay and you get someone else to swear an affidavit.
Okay.
Would you attach their affidavit as an exhibit, or do you just attach it or do you just file it as its own affidavit all on its own and then reference it in your affidavit? Does that make sense?
Yeah, no, I understand what you mean. So let's say you're right. Well, no, see, okay, let's parse that out. First of all, if you're doing an interim application, you can use hearsay.
Yes. But if it wasn't an interim application and you got someone else to swear the affidavit saying... Or
it was double hearsay and you couldn't use it.
Yeah.
Then what you would do is you would have that person swear their own separate affidavit. They wouldn't be attached to your affidavit whatsoever. It's its own document. It's its own sworn evidence of that other person.
Okay. And then so say this is Supreme Court, on a notice of application, you would just list their affidavit as...
one of the materials you're going to rely on.
Yes. Okay. Perfect. Thank you.
And then you don't need to cross-reference it in your client's affidavit, because whoever's arguing it is just going to go to that affidavit and said, look, Ted was in the park with a Frisbee and a squirrel. It's in Ted's affidavit.
Okay.
So your client in their affidavit doesn't have to say, Yoko told me Ted.
Okay. Okay.
They don't even have to say, I understand. Like it'll obviously... There's some reason you're offering that evidence.
Right.
And so it fits into your client's narrative somehow.
Right.
But you don't actually have to cross-reference it. It stands as its own evidence. And when someone's arguing it, they're going to use both those affidavits and say, okay, we have evidence from this person saying this, and we have evidence for this person saying this. And when we take the evidence together, we say it means this. Great. And that's what that's an argument, right?
Yeah.
Does that answer your question?
Yes, it does. Great. Thank you.
Okay.
But I also had another question that kind of goes back a little bit.
Okay.
When you were saying you can't use a doctor's note, or the portion of a doctor's note that explains, that says they can't work for 9 months. So if the doctor puts in that note why they can't work for 9 months, would you be able to use that? Due to this injury, due to their broken.
Not really. It's still opinion.
Darn it. Okay. So a doctor's opinion is not credible enough in court.
It is, but the doctor has to come and give it themselves.
Okay.
It's expert evidence.
Okay. Okay. Great. Thank you.
Now you can try and be sneaky and just attach the document and then hope the judge reads it. You shouldn't do this. Hope the judge reads it, or you can even be quite forward about it. And look, I'm only putting this document in for the fact that the person had the injury and had the surgery. I know the doctor gives their opinion there, but I'm not relying on that.
Oh, okay. I mean, it just happens so much.
It happens all the time. And then judges say, well, the term is, I'm just going to disabuse my mind of that evidence. Okay. Right. Right. I mean, I don't understand how you do that. Yeah. Right. And how do you think, I mean, I guess they're judges. They're going to say, look, I'm just going to pretend that that's not there. It's not proven that this person can't work. So yeah, I guess you can see that. But I have had lawyers actually, I think people put that in knowing that once it's read, it can't be unread. Mm-hmm. And I've actually had a lawyer say to me, well, I put it in there, you throw it at the wall and it sticks. Well, what does it matter? And for them to admit that was pretty awful. They're basically admitting that they're misleading the court. The smart ones would never admit that. They'd say, well, it's just part of the document. Really, what you should do is black out that part. Okay. But people don't. Yeah. Okay. And then you're just, again, asking a judge to disabuse themselves.
No, that's perfect. Thank you for clarifying.
Yeah. So information and belief, we'll quickly go through this bit, and then I think we'll have a break, because I was saying to Lois earlier, I think, maximum concentration is about 20 minutes, or good concentration is about 20 minutes and maximum is about 40. And we've been going close to an hour now. So this is one of the last things about hearsay, and it seems kind of ridiculous, but where hearsay evidence is used, you have to say where it came from. Well, we already talked about that. You can't have anonymous hearsay, right? But you also have to say why they believe it to be true, right? And it doesn't have to be any great detail. And so I put an example, it can be as simple as, on the afternoon of November 4th, 2020, my neighbor, Jianmin Jiang, told me that he was on his porch and saw Louise enter my house at approximately 2 a.m. that morning. He was wearing a watch and checked the time because it was late. I believe this to be true because Mr. Jiang told me so. So it can be as simple as that, right? Mr. Jiang told me, so that's the information, told me X. I believe it's true because he told me. And it seems kind of circular. And you don't have to go into, and I believe he's a truthful guy because I've known him for years, and he would never lie, and his job is this, so he can't lie there. You don't even have to go into that. You just say, I have to believe it's true because he told me it's true, right? Again, it's better if this was some kind of critical thing to have Mr. Jiang swear his own affidavit, but you don't have to, right? Let's take a 5-minute break. It is 2:59. Let's come back at 5 after 3. I'm just going to leave this on because I'm afraid that if I touch it, it's going to explode. Is it
possible to just go back to the last slide so I can just look at it on the break?
There you go. Anyway, I'll see you all in 5 minutes. Might also be expert, right? But they give you even more detailed examples of expert evidence, right? And that's an opinion that includes statements about facts that are beyond most people's knowledge. So this is where you need an expert, right? Ted's kleptomania is caused by high levels of lead in his well water. Come on. That would be expert evidence, and I don't know who you'd call for that. Ted's results on the personality inventory indicate that he is a narcissist. And these are the most common kind of things you're going to get from people. I think my ex is a narcissist, and sometimes they're right and sometimes they aren't, but you can't actually say that unless they've been diagnosed as a narcissist. Maybe a lawyer might in argument say this is narcissistic experience, not narcissistic behavior, but you're probably not going to get away with that. You might, but certainly this is expert, that you're getting into expert territory. And to have an expert, and you can't just get any old doctor either. They have to be an expert in their field. And you have to call them as a witness, and then they have to be certified by the court as an expert. So you have to bring their resume, sometimes have them ask questions, talk about, tell you about the papers they wrote on lead in water wells and its effect on kleptomania. It seems far-fetched, but and perhaps that's why it's the example. But it's not as simple as even having a letter on a doctor's letterhead. It's a much more complicated process. The most common experts in family law are appraisers who appraise the value of family homes. That's an expert report. And so you see those a fair bit. And usually they're not that controversial. They can sometimes require the person. So you can submit, I take that back. You can submit an expert report, and as long as nobody objects to it or applies to cross-examine, then it's taken that the person is an expert. But I won't go too much into that. And there you go, a list of people who could be experts, right? And I'd say there that the court will generally allow but ignore common types of expert opinion, right? I think Ted's an irresponsible father. Tons of people say that kind of thing. You're not going to sit around and argue about that being too much being opinion. I might object and say if I was the opposing counsel and say, oh, objection, it's opinion. Probably not even. Of course, the other person thinks Ted's an irresponsible father. That's probably why you're in court. If they didn't think they were responsible, you wouldn't be there. But won't allow expert evidence such as the Ted's kleptomania, because that's just, it's far-fetched and it would have to require an expert. The other kind of thing you don't want to put in, and Krieber and Franklin's the case for this, and this is my favorite quote, what you don't want in an adjective, in an affidavit, is you don't want it to be quote unquote larded with adjectives. Every time you put an adjective in a affidavit, think about whether it's necessary. And I would suggest to you that 90% of the time it isn't, right? Especially when speaking about the other person. In fact, it'll just go against your client if every second word is particularly about how awful the other person is. So look at every adjective you use. That's an argument where the lawyer is going to say the awful things about the other person based on what they say the evidence is. Or self-serving protestations of surprise, shock, or disgust or other emotions. They don't help you. They don't help your client. I can't believe he did this. It doesn't matter whether you can believe it or not. The facts are what he did, right? Not whether you could believe it or you were shocked or disgusted by it, right? The evidence is what the person did. And, depending on what happens with that, your lawyer might stand up and say, this is shocking. I can't believe it. Not unlikely. But again, that would be for argument. That's not evidence. So think about adjectives when you put them in. Are they really necessary? Going back to you're trying to have an objective portrayal of the evidence. Oops. Okay. Legal argument. So we've kind of crossed over on this too, right? Affidavits may not contain legal argument, even where the argument is phrased as hearsay that would normally be acceptable. And that's really the second paragraph. I am advised by my advocate that because the respondent and I separated more than 2 years ago, we are no longer spouses. Well, that's argument. The fact in your affidavit is the respondent and I separated on X date, right? And then if you're representing yourself or if you have a lawyer, then you're going to argue, we're not spouses anymore because it's been more than 2 years, right? But the evidence itself is just the date you separated, right? The other one there is the respondent maliciously attacked me, right? That's argument. It's not just using larding with adjectives. You're saying that they attacked you and is malicious. And we'll actually get to an example of how you would rephrase that, but that's not evidence. The evidence would be the particulars of that attack, right? And you win an argument, you might then stand up and say, the respondent maliciously attacked me based on the evidence that was in my affidavit where you described what happened, right? But that's legal argument. Do you want to get away? And when people write their own, they always want to put in argument. They always want to put in lots of adjectives. They always want to say, he was a crap father. Well, you don't have to say that. You say that in argument after you go through your affidavit, showing all the things that point to that he was a crap father. And then you're going to stand up and say, based on the evidence, he was a crap father. You don't put it in your affidavit, right? So that's most of the information that I'm going to give you. These are problematic statements. This stuff's a bit more interactive, so we'll see if people respond, and if you don't, I'll just kind of go through it. And we can look at things that people have put in affidavits and what's wrong with it, A, and B, how you might rephrase that, right? So let's take a look at the first one. Oh, I put in a cartoon. I swear to tell the truth, the whole truth, and nothing but the truth from my perspective. Now that's supposed to be funny, I think, because I'm going to tell the truth, but it's from my perspective, so it's going to be biased, or it's going to. Well, from what we know about memory and psychology now, that's actually quite true. Everybody's truth, what everybody remembers, is entirely from their perspective, and it changes. And different people may be somewhere and experience the same thing and have entirely different views of it. So, yeah, I don't know. That's an aside. So here's a statement. The respondent and I. What time is it? 3:15. The respondent and I began cohabitating on June 1st, 1993. And here's the malicious attack. We separated on September 15th, 2013, when the respondent maliciously attacked me and the police kicked him out. So, one thing we didn't talk about, and I don't know if it's relevant here, is also speculation. You can never speculate about what other people are thinking, or what might happen in the future, or why somebody might have done something. And I'm going to make a note of myself to put that in it when I do this again, because speculation is a big one, right? You can't speculate. You can only speak to what happened, right? Anyway, this statement, does anyone want to have a shot at what's wrong with it?
I don't know if I would even use the word cohabitating if I want it to be in my client's words. I might just say that we began living together on June 1st.
Good one.
And then instead of saying the respondent maliciously attacked me, I would probably say, I would go into not too much detail. I'd still be concise, but I would say the respondent and how he attacked her, like kicked me, hit me. And then I called the police and they asked him to leave, because the police don't generally kick people out. They ask them to leave. So maybe that's I would change a little
Or
bit.
they arrested him, or whatever the case may be.
Yes.
Right. Kicked him out is kind of slang.
Yes.
Right. So I think you nailed that one. I don't think I have a whole lot more to say about it. And I like the cohabitating. No one's ever said that before, but you're exactly right. That's not plain language, is it?
Yeah. No, it's not. No. I've never had a client say that to me. No.
Yeah, maybe occasionally. So it's argument, right? Like we were talking before, maliciously attacked. And I think addressed what you would do to change it. You would describe that malicious attack, and then your lawyer is going to argue that it was a malicious attack. But yeah, exactly. You're going to put in exactly what happened. And you might do it in some detail. If it really was a malicious attack, you probably are going to do it in some detail, because it's probably pretty important. And then if the police, you are going to want to differentiate. Probably if it's a malicious attack, the police did arrest him or her. And then and then you're probably going to have further evidence and further paragraphs about what happened after that. If he actually was arrested, you might have stuff about, well, he was released on bail, but he has terms or he can't, there's no contact terms. And then you're going to be attaching his bail conditions, which the police usually give to someone who's subject to protection under the bail terms. And you're going to say, you might even have documents from court services online saying, because you can go in on a court services online and any active criminal file, you'll find documents about what's going on, when their bail hearing was, whether they were released or not. You'll be able to say whether they were in custody, when their trial is, or what the next, if it isn't set, what the next appearance is. You can find all that stuff out on court services online. And generally you can use that as business records, right? You have to be a little more precise about it because it's from the internet, but you would have your client download that, attach it to their affidavit and say, at such and such a time, I went to court services online at HTTP and put in the address and the time they did it. And this is what I downloaded, right? And from that document, you can glean that perhaps they have another court appearance, or you can just attach, the Crown, after his bail hearing and he was released with terms, the Crown contacted me and provided me a copy of his bail conditions and marked and attached as Exhibit B or his bail conditions like that.
Patrick, elaborating on the living together, would it be beneficial to put in a marriage-like relationship or?
Yeah, you could. I mean, I guess it's possible. I mean, I think generally people will understand that to mean a romantic relationship.
Okay. That
you were partners. Probably where you could put marriage-like relationship. Is that a legal term? I don't know about that one because people put it in there and I think, I think where you'd want to be clear is if you moved in together and you were just roommates, you would want to say that.
Okay, right, good.
Like we moved in together on September 15th, but we were just roommates. You know, we then developed a romantic relationship. I haven't come across that a whole lot. I think it's generally understood that if you'd said living together, that's what it would mean. But yeah, technically that isn't necessarily true, is it? I have two wonderful, kind, and caring children named Austin Lee, born November 1st, 2005. There should be a comma after 2005. And Jennifer Grace, born November 2nd, 2006. Anyone want to have a shot at what's wrong with that?
I don't think you should have wonderful, kind, and caring children.
Nope.
Take that out.
Nope. Larded with adjectives, right?
So
yeah. Why is it relevant they were wonderful, kind, and caring? And if they were,
yeah,
what would you do if it was somehow relevant?
Yeah.
What would you do if it was somehow relevant they were wonderful, kind, and caring? What would you do instead?
What would I do instead? How would I write that?
Yeah.
I have two children.
Yeah.
Named Austin Lee,
yeah,
born November 1st, and Jennifer Grace, born November 2nd, 2006.
Yeah.
End of story.
That's generally what you would do. Yeah. But let's say you did, for some reason, and I can't really think of one, if you were going to, as evidence, want to show that your children were wonderful, kind, and caring, you can't just put that they were wonderful, kind, and caring. You would have to describe things they did that made them wonderful, kind, and caring. Right? Austin brought me fresh cut flowers every morning. He'd wake up early and go and get flowers and bring them to me in bed. Now, I don't know why this would ever be relevant, but, and then if you needed to make the argument, then who's ever making the argument would say, look at, he brought flowers to his mom every morning. Look how wonderful, kind, and caring he is. But you would never just describe them as that, right? Okay, what do they say? Yes. Oh, okay, this is an interesting commentary. Describing the children using possessive language in the first person is the fastest way to ensure the court suspects your client may not fully comprehend what the children need and what is in their best interests. Huh. I think that's true. We're going to have to rethink whether that particular comment is entirely true. You often do see affidavits where people just kind of lay out, my kids are great, and they're great like this, and great, and great, and great. And you think, do you understand what's really going on here? The other thing is, don't expect the court to do the math, put their actual ages. So November 1st, 2005, brackets, 14 years old. Right.
Patrick, there's a couple of comments in the chat.
Oh yeah, let me know what they are.
One is, would you state that that they are of the marriage? I think this is in relation to this.
No, I mean, yeah, because generally speaking, that's a good question, because it takes me to the point that when I phrase children at the beginning of an affidavit, I do use that term sometimes. I would say of the marriage or the relationship. And it's one of the first things I put in as background, right? We met here, we were married here, there are two children of the relationship or two children of the marriage, namely, and then list them. So yes, you would do that. Yeah.
Yeah, someone was saying it probably would have been stated earlier though.
It's usually right at the beginning. I think if you look back at the affidavit example, it's going to be on the first page, right? And then if for some reason you need to describe, like you put that right at the start, and then when you're going through your narrative, you might may just have a general statement saying there are 2 children in the marriage, namely, and list Austin, Lee, and Jennifer. And I would put their last names, unless they have different last names and Lee and Grace are their last names. But you might discuss again in your narrative, just so it's not awkward at some point. And, because you're discussing the background of the relationship, and then you're saying, and our first child was born on November 1st. So you might list it again. If it's kind of makes the narrative more flow better. But yes, you could say 2 children in the marriage. I mean, is it a legal term under the Divorce Act? Yes, it is, but it's not a bad way to phrase it.
Another question related to this, sorry, I think you
that's great.
Is would you say we've got 2 wonderful, kind, caring children, or, except for not.
You wouldn't say wonderful, kind, caring ever.
Right. But would you say we rather than I?
Yes. And that's probably why I've said here, don't use possessive language. They're not just your kids. So yes, thank you for pointing that out, because that's exactly why. They're not just your kids, right? There's usually more than one person involved, or you wouldn't be in court. There's usually more than one parent. I just usually say there are 2. Right. You could say we as well, right? We have.
And there's another question.
Okay.
What if you're fighting over the family pet? Where do you include that?
Oh God, I hope I don't.
Sorry.
Do you put it at the beginning in the background?
I guess the question is, you're talking about the children. Is the next paragraph talking about the pet, or?
If there is one, yes.
Okay.
If it's an issue, then yeah, you want to address it early. There is a pet. There's one pet of the relationship, one pet of the marriage. I've never heard that term used, but, and I'm trying to be dismissive of pet lovers. But yes, yeah, you can put it at the beginning of the background, and then if it's part of the narrative as well, on such and such a date, we bought a dog, and, explain the process, and then, whatever facts are relevant to your claim around that pet. Yeah, absolutely.
The discussion in the chat is a family pet more of an asset than a family member?
Technically, I would suggest that they're an asset, yes. Does it cross over because it's emotional, and do people recognize that? Yeah, of course, right? You're not just fighting over an asset. There's emotional connections to pets. I'm getting 2 new cats on Saturday. I'm pretty excited about it. So there you go. You know what I mean? There's excitement. There's emotion. So yeah, list your pet. It comes up so rarely for me, but I know it is a thing. Is that all the questions from the? That's
it. Yeah. Okay. No.
Great. Yeah. No, thanks for pointing that out, because that's exactly it. It's I have not recognizing, sorry, these children aren't just yours. The children and I live in our home in Vancouver. The respondent lives way off in North Vancouver in a dark and damp basement suite. What's wrong with that? Anybody want to have a shot?
I'm guessing it's the dark and damp basement suite.
Yeah.
And lives way far off.
Yeah. It's dark and damp. So let's see what I wrote. Unnecessarily exaggerated, dramatic, and no basis establishing the source of information. And again, larded with adjectives or self-serving protestations of surprise, shock, or disgust, right? Can you believe he lives way off in North Vancouver in a dark and damp basement suite? Now, the fact that you live in Vancouver and the respondent lives in North Vancouver in a dark and damp basement suite could be relevant, though, right? Could be relevant in all sorts of ways. So what would you do instead? Anybody? What you do instead is describe where they live and why it's relevant. So you would say, I live, and you'd be more specific. I live in our home in Vancouver, in South Vancouver near Fraserview, right? The children you might want to include the children go to school 3 blocks from the house. The respondent lives in an apartment at such and such address in North Vancouver. I know this because I've been there to drop the children off, right? You might have evidence about how long that drive takes. I've made this drive a number of times at different times of day. At rush hour, that drive takes 58 minutes on average, because it might be relevant, right? It might be relevant as to parenting time, because is it reasonable to expect someone who lives in North Van to have weekday parenting time? And is it reasonable for a child to commute from North Vancouver to Fraserview, right? So it might be relevant, but you have to describe why. You know, you might even attach, you know, Google Maps. At 3 o'clock, Google Maps says it takes this long to drive from there to there. Normally it'd be your own experience, but you could also do that. Dark and damp.
Oh, sorry. People in the chat were just saying add the actual address, but you're saying more than that, really.
Oh, you would definitely add the actual address. You can add more. It just depends why it's relevant, right? Like if you're trying to make the argument that he lives too far away, you might want to have a bunch of reasons. Like what's the reason? Why does it matter if he lives far away? Right. So you want to explain that. And the part of it is because he's trying to get weekday parenting time and he wants to drive him back and forth every day. You might want to explain that.
The dark and damp part, would that be relevant if one of the children had, say, asthma or something?
Exactly.
Okay.
Yeah.
So
but
just the context has to be
right
out.
So in your affidavit, you'd say, you know, one of the children has asthma.
Okay.
But how do you change the language around dark and damp basement suite?
Because the child has pre-existing condition.
Yeah.
He needs to have more ventilation, or I'm not sure. I don't know about that very much. So.
Well, I think the idea would be explain why you know it's dark and damp. You can't just say it's a dark and, you know, you have no well, how do you where's your evidence that the basement suite is dark? How do you know?
The child comes home and tells me that it's dark and damp and he needs to use his puffer every time, or
bingo.
Okay.
Exactly. That's exactly what you put. How do you know? Right? It's not just enough to say it's dark and damp. Well, you could say the kids told me. You could exactly say medical evidence is it's gotten worse. He has to use his puffer. He tells me he uses his puffer every 5 minutes while he's there. Or when I dropped the kids off, I looked in and I saw a black mold on the wall, you know, which is unlikely, but if it's evidence. So when people tell you in the interview, oh, he lives in a dank and dark basement, so you have to say, well, how do you know? What's the evidence to support that, right? But that's exactly what you would do. And that's exactly why it'd be relevant is, you know, if one of the kids has asthma, it's not a great place for a kid to be living, right? Now they might come back and,
There's more talk in the, someone was saying, as you, I think, were saying, if a child has certain symptoms when they come back from the dads. Someone else is asking, how do you make dark relevant?
Yeah, you don't, do you? No, I think dark is connected to damp because light takes out damp, right? But yes, no, the critical, yes, no. The critical point there is it's the damp that's the problem, right? Yeah, how do you make dark relevant? Good point. It's really the damp that's the issue.
Yeah, that's it for the chat.
Okay. All of my friends have asked me in the past, why do you put up with such an abuser? I know they care about me and believe the respondent to be a batterer, which I agree with. Okay, what's wrong with that? Is there anything right about it?
Yeah, everything's wrong about it.
There's nothing right.
Yeah, it's hearsay, it's opinionated, it's filled with adjectives. Yeah.
Yeah. I mean, it's not even hearsay because, well, I mean, I guess so. I mean, I guess they're saying, I know they believe the respondent to be a batterer, but it's just hearsay from you, right?
Talks about third-party opinion.
Yeah. Yeah. And so, you know, okay, friends not identified, even if they were, it's hearsay. We got that. Even if it was admissible, it's hearsay as opinion because they say he's a batterer without qualification, right? People do this a lot, right? What where they have a situation where they say, oh, but I told lots of people. Not really relevant, right? Unless it's brought up. Like, for instance, if something happened, if there's an incident that happened, it doesn't matter so much if all your friends think that the person's a batterer. It doesn't matter. If your friends saw some of it, then of course you'd probably have them swear their own affidavit, because that would be the most powerful evidence. It's funny because you're not technically supposed to say you told anyone. That said, for instance, when some kind of dramatic incident of violence comes, the other party or the lawyer is going to say, well, did you report it to the police? And of course, there's lots of psychology around why people don't report family violence, and you can use that to explain it. But it does carry some weight, even if you did report it to the police, and if there's a police report. And I guess that's because, if it didn't happen and you reported it to the police, there's consequences. So it does lend some weight to something like incident of violence if you reported it to the police. Whether you told other people, I've even heard people on cross say, well, did you tell anybody? And I don't know that matters, but it does come up. This statement's useless. The respondent, time is at 3:30. The respondent failed my son when he did not take him to his Saturday soccer practice on 3 occasions since separation. Once in October of 2013 and twice in November of 2013. Austin was hurt and upset and suffered emotional abuse. Now, I think I actually referenced this situation when we were talking about it before, and this is probably why, but what's wrong with that? Speculation?
Conclusions. And
yeah.
Once in October, there should be dates, not just once and twice.
It would be better if the dates were more specific, but if you can't, if you don't, it's okay.
I mean, you can't say he failed your son. That's not.
That's opinion.
I don't even know what you'd call that, but it's not admissible.
It's opinion.
Yeah. So.
Yeah. The fact
there's a lot of opinion in there.
Yeah. And there might even be expert opinion.
And he can't say Austin was hurt and upset. He could describe what he observed, but he can't give an opinion on what he was feeling.
Right. Exactly. And suffered emotional abuse, that might even be expert opinion, right? Let's see what it said here. Unnecessary exaggeration, argument coupled with opinion evidence. So failed my son is that's argument, right? And I guess that's what the exaggeration is as well. The fact there is that the respondent didn't take the child to soccer practice, right? And the fact is that whatever Austin did to display that he was hurt and upset is argument, right? So I think we've already identified what you do is you describe what Austin did and what you observed. Like Austin cried when the respondent didn't turn up on October 12th. Austin cried again when he didn't turn up on November 16th. Austin told me that he really wanted to go and was disappointed that he didn't go. Austin told me he loves soccer and hates missing practice, right? So children, it's hearsay, but it's from your child, and that's always admissible. But that's how you would rewrite that. And you'd take out failed. I am totally and completely devoted to doing everything the child needs. The children need, sorry, it is plural. Whenever they need it. I am shocked and dismayed. They even use shocked and dismayed. Or I did. At the respondent's lack of caring. I was told by my brother Sam that he spoke to the respondent and the respondent talked to him about work, telling him he was busier, that should be than ever, but never once mentioned the children, ! What's wrong with that?
Hearsay and double hearsay?
Double hearsay. Yes, there is double hearsay in there. And it's never admissible. Anything else?
totally and completely devoted, shocked and dismayed.
Yeah. Shocked and dismayed. Sorry?
Exclamation points.
Never use an exclamation point ever in an affidavit unless it's a direct quote from something. Okay. That's a rule. If it's a direct quote from something that has an exclamation mark in it, fine. That would be the only time you would ever use an exclamation mark. Yes, there's double shock and dismay. It's protestations, right? It doesn't matter whether you are dismayed about the respondent's lack of caring. If you really thought that was relevant, and it may well be, then you would describe things that the respondent did. And then in your argument, you'd say, look at these things the respondent did. The respondent really has a lack of caring. If you were going to do that. I am totally and completely devoted to doing everything that children need whenever they need it. That's pointless. There's not much that you could actually save or is relevant from.
That's actually the comment in the quote. Someone was saying they didn't think they would use any of the comments in this example.
Exactly. It's kind of useless. You would just strike that paragraph. Adjectival lard, opinion, argument, double hearsay, inappropriate use of unnecessary punctuation. Yeah. No exclamation marks. And I mean, technically you're not supposed to use contractions either in legal writing. People do anyway, but you're not supposed to. I mean, if someone says can't, it doesn't say cannot, if it's supposed to be in plain language, but yeah. The children don't want to live with the respondent. I know this to be true. The children are very close, and I know that they prefer to live with me. I love them and would do anything to protect them, as any good mother should. I should really change that to father. Gender stereotyping here. What's wrong with that?
Someone says speculation.
Yeah.
It's her opinion.
Yeah.
Someone says everything.
Yeah, I mean, it's not completely useless because it's trying to express that the children don't want to live with the respondent. I think that's legitimate. This thing, the way it's put here is yes, not useful. So there's a couple issues with this. First of all, well, we've identified a bunch of issues with it. First of all, if you wanted, what would you do to rephrase this? Anybody?
It is my understanding that we could use hearsay evidence if it comes directly from the children.
You could.
So we could maybe say that the child, name X, whatever, has expressed to me that they do no longer want to live with their father, and maybe provide some other further evidence.
Yeah, exactly. The child told me. That's what you said. If the child tells you, I don't want to live with the respondent, you can use that evidence, right? If the child said to me, I would prefer to live with you, you can say, the child told me on such and such a date that they would prefer to live with me. I mean, you're generally probably not going to get an exact quote and you're going to paraphrase, but that is absolutely evidence you could use. Yeah.
There's a comment that children will say what the parents want to hear.
Right. Exactly. It's self-serving, and parents, they might tell, and judges understand that. Those are good comments. The children might tell both parties the same thing. Right. And so what's a judge supposed to do with that? So I think you're exactly right there. Perhaps the entire thing is completely useless. Another state of mind, inadmissible. Hearsay from a child, generally inadmissible, but must be set out with a specific attribution. And there's something that I forgot to mention. The children are not a Borg. The children can't tell you something together unless they say it together at exactly the same time, which is unlikely, in exactly the same phraseology. So you have to identify the children. They're not a Borg. And that, regardless of if this subject material is not so useful, remember that the children can't speak as a unit, which is why you must make anything they say specifically attributable to them, right? in as close to the original phrasing as possible. And then the other issue there is argument, right? Let's see here.
Question. Can the child write an affidavit on his or her own to present it to the judge?
No. And it's problematic when they become teenagers, right? I have seen people turn up with a letter, and they're usually self-represented people, turn up with a letter from their child saying they don't want to. They want X. The only time I've ever taken it into consideration was in a very serious situation where some years before, one party had allegedly contracted to have the other party killed. And the judge was so concerned about this that they took that letter into consideration. But generally speaking, you won't see judges consider letters or evidence or affidavits from children, particularly young children. But the only time I've seen an affidavit from a child is where it's very uncontroversial when you're applying for guardianship and everybody agrees. So let's say a kid lives in Vancouver and they're living with their grandparents because the parents are living elsewhere, and they want to add the grandparents as guardians. And you make an application and everybody's on board because technically the applicants are the grandparents and the respondents are the parents, right? But it's usually the parents' idea. I have seen affidavits from a teenager saying, yes, I live with my grandparents. I would very much like them to be my guardians. I've never actually done it. I usually have the kid come to court. Now the courts, and then say, look, the kid's here. I can tell you that they consent to this, and then the judge can actually ask them. With small children, it's a non-starter. Yeah. Yeah.
I have had a case where my client was, of course, self-represented. The opposing party had counsel.
Yeah.
And they brought typed up letters by the children in court as evidence. And I informed my client to ask the judge to dismiss those, and the judge allowed it. And it was letters by 2 children. And I was quite disappointed by that because as an advocate, you try your best to stick by the rules and follow everything, of course. And then you show your client that that's not a good example, but the judge ended up allowing that as the opposing counsel was there also. So quite odd case, but I guess anything is possible.
It is. And like I said before, the lawyers, don't necessarily know the rules of evidence, or probably in that situation, they're trying to take advantage of the fact that your client was unrepresented. At the end of the day, the fault there lies with the judge. The judge should not accept that, right? The judge should not accept typed up. What did the kids type them? How old were the kids, right? That's very problematic. And you are going to come across, and then, you're put in the position of, what if your client wanted to do that and you told them they couldn't, right?
That's what happened.
Yeah. Oh, that's even worse. So that's just an awful situation. That's kind of out of your control. And that's awful judging. And it's an opposing counsel taking advantage, because you shouldn't do that. And that comes back to ethical. I mean, what do you do there? Right. Because we already looked at section, I think it's 225, right? Where judges can do anything that they think is reasonable to take evidence from children, but it still has to be reliable, right? And that evidence, those letters are, how do you know the kid even wrote them? And if the kid's 6, who typed it? And is it reliable when it's that self-serving, right? And I would object strenuously to that, but the person was self-represented. And it would be the kind of thing where you would not only object strenuously as a lawyer, but you would say, you make it very clear that you thought that was going to be the subject of an appeal without saying as much, right? You'd be saying, I'd like everyone to know I'm going to be ordering a transcript of this proceeding, right? As a signal to the judge that That said, they might just rely on Section 225 and you might not get very far, but yeah, that's a awful story.
Question in the comments about at what age could a child come to court and speak on their own behalf?
Teenager.
Okay.
You know, it's kind of when the courts also recognize that children start to have a say in where they live and what they do, right? And until they're kind of like 14, and the expression is children vote with their feet, right? Mm-hmm. It's like you can't make a 15-year-old live somewhere where they don't want to live, and judges generally won't try. You know, it's where you start getting the really tired alienation arguments, right? But yeah, you can't. I mean, I had teenage children. You can't make them do anything they don't want to do for the most part. That's also the point where they can come and give their own evidence. Now, I've never seen it done except in that circumstance I described around guardianship. I do know that judges have requested very occasionally where there is no Section 211 report, or it just can't happen, or the people don't have the money to do it, or for some reason the family justice counselors aren't available, or there's some kind of critical time frame thing going on. I've never actually seen it done, but I do know judges can order kids to come in. Usually they won't have the children because they feel like they'll be under pressure in the courtroom. They'll usually have them come into the judge's chambers and the judge will interview them alone. Right? So they're not standing there with their parents staring at them.
Patrick, when you said you'd be asking for a transcript, someone's asking what would be the basis for the appeal? Like, what would your argument?
That they've taken evidence that's unreliable, unsworn evidence that's unreliable and could be biased. And we have no way of knowing that that those were statements from the children.
Okay. And just a heads up,
and so they're taking it as fact that, there would be argument about what's in their best interests through unverifiable, unsubstantiated evidence, right?
Okay. Heads up, we're about 10 minutes to the end.
Yeah, I have it 7 minutes to the end. This is the last couple slides.
Perfect.
So I can go through this slide, or if people have questions, we can spend the last 7 minutes doing that. I'm easy either way. If you have questions, shout them out now because we're going to run out of time. Otherwise, I'll just keep going through the last couple slides.
There's someone who already has an answer to the most recent, the post thing you've posted up. They
already have an answer to the terrible drunk?
Yeah.
Yeah, nothing seems to be able to help him. Not only is respondent an alcoholic, he also has broken the law by having his license suspended for drink driving, thus demonstrating his contempt for the law in courts. What did the person say in the chat?
It said adjectives, drawing conclusions, expert testimony, alcoholic, no evidence, seems to be. What does that mean? And is there a good drunk?
Yeah, those are all good points and they're all true. Yeah, I nailed it. Opinion, adjective, lard, opinion, conjecture, argument, likely the entire paragraph is inadmissible. What would you write instead?
The respondent has a history of alcoholism. He's had his license taken away said number of times over the course of said number of years.
Yeah. I don't think you'd say alcoholism unless they actually had a diagnosis. But you could say a long history of alcohol use, right?
Okay.
And you would describe it, right? You would give the evidence to describe why you thought the person wasn't, if you lived with them for years, he would start drinking every afternoon at 4 o'clock and, he'd pass out on the couch at 10:30 and, by 9 o'clock, he was slurring his words and, he smelled like alcohol and his eyes were bloodshot and he sent me to the liquor store 3 times a week. And, we spent $400 a week on liquor and, judging by the empties that I returned, he drank X bottles of vodka and X numbers of beers per week. And here's the receipts from the liquor store, or here's my bank statements from the liquor store. And I had the occasional drink, but he drank 95% of it. I mean, there's all sorts of evidence you can give, right? About that. Yes, and he had his license suspended. Sorry?
Someone's asking whether you attached the CSO.
If you had one, yeah, absolutely. If you had any documents relating to the suspension of his license, you would absolutely include those. And if you didn't, you just have to give your evidence of why you knew. He told me. I had to pick him up because he got a roadside suspension. I had to go with the keys and drive the car home. I had to drive him everywhere for 6 months because he couldn't drive the car. But he did on these occasions, and I know he did. I don't think you're not gonna argue that he's demonstrating contempt of law in courts. You're gonna say that, you're a lawyer, or you might say that in argument. But if you said, yeah, I mostly drove him every 6 months, but there was a couple of times, there was also a couple of times when he drove anyway. I saw him. He left the house. He took his keys. He took the car.
Is it helpful to put in pictures of empty beer cans and alcohol containers?
You could, I guess. I mean, I have seen it done in situations where, someone had a party. Yeah, I have seen that.
Okay.
Yeah, you could say, here's a picture. You're probably not living there anymore. If you're at the stage where you're not living together anymore, if you're in the stage that you're swearing an affidavit or something. But yeah, I've seen pictures of, they're partying all the time. When I dropped off the kids, this is what the house looked like.
Okay.
Right.
Okay. It was just, I have someone who in the past did put pictures of the weekday empties, I guess, of her ex.
Right. Here's the recycling bin.
Yeah. I just didn't know.
Yeah. I don't know. Okay. That's harder.
Okay.
Because it could be anybody,
that's what I thought. Yeah.
The evidence around, how do you, it depends on the context. How do you know that person drank all of that? Right? The evidence that I described as I would buy drinks for him, I would go every day and buy the booze. I returned the empties and it was always this much, all that kind of evidence about things that actually happened over the course of time. Maybe you support that with, here's a picture of the empties. But if the picture of the empties is your only evidence, not so much, right? Maybe they didn't put out their empties for a month. Maybe they had a party and 12 people drank that amount of alcohol, right? So if you're just dropping off your kid and you see a blue bin outside and it's full of empties and you take a picture and use that as evidence that they're drinking a lot, I don't think you're going to get very far with that.
Yeah. Okay. Thank you.
Right. So it's context, really.
Yeah.
Oh, last slide. And do you see that no good, low down, dirty hornswaggler in the courtroom today? Oh, another hilarious comic. 3:59. How good is that? Hey. Anyone have questions? Because you got a minute.
This is 1 minute long. We're good. No, does anybody have questions? Truly.
Mm-hmm. And I appreciate that people did chime in and ask questions. I know that's hard in this format, so I appreciate everybody doing that.
I really appreciate you giving this brief today. It was very good, very helpful.
My pleasure.
Yeah, it was excellent.
I was saying to a couple of people at the break, I don't know, I may end up doing it again. And like I said, I do this for law students. But if you have a survey and there's any kind of feedback about if I do end up doing it again, what was useful and what wasn't, if you all know what an affidavit looks like and that's kind of pointless, let me know so that I can try and improve it.
Yeah, that's great.
Yeah.
Well, thank you very much. And I think that's the questions in chat. And
okay.
Now is a lot of thank yous and saying that they appreciate your presentation. So thank you very much.
Thanks, everybody.
Bye, everyone.